Hi, today I'll be dealing with the topic legal position of a daughter of a Coparcener in Hindu joint family with reference to Hindu Succession Amendment Act of 2005. I would be dealing this topic in four parts. The first part is the law prior to the enactment of Hindu Succession Act of 1956. The second part is the law after the enactment of Hindu Succession Act of 1956 but prior to the enactment of Karnataka Amendment Act of 1990. The third part is the law after enactment of Karnataka Amendment Act of 1990 but prior to the Hindu Succession Amendment Act of 2005. The fourth part is the law after the enactment of Hindu Succession Amendment Act of 2005. So let's begin with the topic. Who is a Coparcener? A Coparcener is a person who shares equally with other Coparceners in the estate of ancestral property. So, we can say that a Coparcener is a person who gets an equal right with that of others in the ancestral property. In a Hindu joint family, Coparceners are a male member of the joint family along with his sons, grandsons and great-grandsons. Hindu Succession Act was enacted in 1956, but prior to that in India, Shastric law or customary law prevailed. The two prevalent systems were Dayabhaga system and Mitakshara system. Dayabhaga system prevailed in Bengal. Mitakshara system prevailed in other parts of India. Mitakshara system recognized two laws, that is the law of survivorship and the law of succession, whereas Dayabhaga system recognized only the law of succession. In Mitakshara law, a female was not given any kind of right in ancestral property. She was not recognized as a Coparcener. However, in British India, there were some legislations which were enacted to give certain kind of rights to the female. The first legislation pertaining to this is the Hindu Law of Inheritance Act of 1929. This act included certain female heirs in the list or the rank of legal heirs. They were son's daughter, daughter's daughter and sister. The second legislation was the Hindu Women's Right to Property Act of 1937. This act enabled a widow to succeed along with the son in the property of her deceased husband, but she was given a limited interest. She could not alienate the property. She had only interest till her life. She had only life interest in the property of her deceased husband, but she could claim partition in it. However, a widow was not recognized as a Coparcener and the daughter was virtually given no inheritance rights in the property of her father in the ancestral property. Hindu Succession Act was enacted in the year 1956 with effect from 17th June 1956. This act, although did not confer coparcenary right to a daughter, but it gave an absolute right to the property possessed and acquired by her. That is, by virtue of section 14 of the Hindu Succession Act, a daughter would get an absolute right in the property, in her own property and the property possessed and acquired by her. So, the daughter got an absolute right in her self-acquired property. The daughter was given an equal right with that of her son in the self-acquired property of her father. This was by law of succession under section 8 of the Act. Section 6 of the Hindu Succession Act retained Mitakshara Coparcenary. The devolution of interest in Mitakshara Coparcenary property was governed by the law of survivorship, but it provided some exceptions. If a male Hindu dies intestate leaving behind female heirs mentioned in class 1 of the Hindu Succession Act, then the property would not devolve under the law of survivorship, but it would devolve by the law of succession under section 8 of the Act. Under section 8, a woman, a daughter, would get an equal right with that of her son and she was given an equal right in the share of her father. So, a daughter would get an equal right in the share of a father in the ancestral property. So, we can say that Hindu Succession Act conferred absolute rights to a female in her self-acquired property and equal rights with that of a son in her father's self-acquired property and equal rights with that of a son in her father's share in the ancestral property. But nowhere she was given or she was considered as a co-parcener in the ancestral property. As a daughter was not considered as a co-parcener, some southern states in India brought some amendments to the Succession Act. So, states like Karnataka, Andhra Pradesh, Maharashtra and Tamil Nadu effected some changes in the Succession Act. In Karnataka, amendment to Section 6 was with effect from 30th July 1994. That it was known as Karnataka Amendment Act of 1990. By virtue of this section, the daughter was given an equal status of a co-parcener. So, the daughter became a co-parcener in the ancestral property. However, this amendment created a distinction between a married daughter and an unmarried daughter. Those daughters who were married prior to 30/7/1994, that is the commencement of this amendment act, were not considered as co-parcener. And another exception was that this amendment act did not apply to those partitions that were affected prior to 30/7/1994. So, this amendment excluded those married daughters and those partitions which have taken place before this amendment, that is Karnataka Amendment Act of 1990 with effect from 30/7/1994. Now, we can see that there was a revolutionary change, there was a revolutionary amendment being carried out to Hindu Succession Act in 2005. The daughter of a co-parcener was conferred with the status of a co-parcener and she was given an equal right with that of a son in the co-parcenary property. So, the daughter by birth became a co-parcener on and from commencement of this Amendment Act, that is from 9/9/2005, that is 9th September 2005. However, there were some exceptions to this amendment, that is those testamentary alienations, dispositions, partitions which have been taken place before 30 December 2004 were not to be affected. The amendment excluded such testamentary dispositions, alienations or partitions. Section 6 expressly kept away two types of partitions which have taken place before 30/12/2004. They were partition by a duly registered document and partition by a decree of the court. So, we can conclude that till 2005 a daughter was not given a co-parcenary right in the ancestral property. She was not recognized as a co-parcener till 2005 except in some southern states, but from 2005, that is from 9/9/2005, that is 9th September 2005, the daughter by birth became a co-parcener and she was given an equal right with that of a son in her own accord in the co-parcenary property. If you like this video, please subscribe to our YouTube channel for more updates.